Thank you. Chairman Grassley, I'd like to ask unanimous consent to enter into the record a letter from 19 different faith-based and secular organizations expressing concerns about Judge Gorsuch's rulings on church and state and free exercise.
Without objection, is centered.
Thank you. Good afternoon, Judge.
Hi, Senator. Good to see you.
It has been a very long and hopefully very informative and instructive day, and I'll suggest...
Take this away from your time, but I want everybody to be aware that after you get done, Senator Coons, we're going to take a 10-minute break.
Thank you, Mr. Chairman. The Third Amendment, some would suggest, was rooted in the Delaware Constitution. So although obscure, it is still beloved by some in the first state. Let's have a conversation, if we could, about religious free exercise and about liberty interest. There's an enduring tension or contest in our history between individual liberty and religious free exercise and the ability of government to enact and enforce neutral laws. And I want to better understand how you view the proper balance between these competing core values. And to that end, I found Hobby Lobby and your contribution to it concerning and interesting. The case centrally involves access to health care coverage, including contraception, for about 13,000 employees across 500 stores of Hobby Lobby and the religious views of the owners of that corporation. And you, Judge, joined the 10th Circuit majority opinion, holding that this for-profit business could, because of the business's religious beliefs, refuse to provide its employees with access to family planning. But you went even further than the majority, writing an additional concurring opinion emphasizing that the owners of Hobby Lobby, the Green family, were entitled to personally raise their religious objections, notwithstanding that they operated the business through trusts and corporations. In coming to that conclusion, you opened your opinion by writing, and I quote, "All of us face the problem of complicity. All of us must answer for ourselves, whether and to what degree we are willing to be involved in the wrongdoing of others." Complicity is not a concept I've seen widely discussed in free exercise jurisprudence. Why did you choose to lead your opinion with this concept of complicity, and what's it mean as we're trying to assess free exercise rights?
So under the religious freedom, Senator, thank you. Interesting, good question. I mean, this is what it's all about. The Religious Freedom Restoration Act protects this exercise of sincerely held religious beliefs and affords them the highest protection known in American law, strict scrutiny. That's a law that this Congress passed because it wasn't satisfied with the degree of protection that the Supreme Court was affording the exercise of religious liberty under the First Amendment. Under Smith, this Congress found Smith, written by Justice Scalia, to be insufficiently protective of the right to free exercise.
If you could, Judge, help me with your choice of the term complicity, which doesn't appear in that statute and hadn't previously appeared in free exercise jurisprudence.
Thank you for prodding me along. The point is, what's a sincerely held religious belief? The individuals there were devout Christians, and as they interpreted their religion, it was a violation, a sin, for them to participate in any way, in signing papers even, to allow the provision of certain contraceptive devices, those that they believed had the effect of destroying a fertilized egg.
Right. And
They were
that's
okay.
exactly, excuse me, Judge, but that's exactly why the question of your use of this term complicity is so interesting to me, is that it opens up a very broad, very attenuated, very remote connection between sincerely held religious beliefs by this devout family through a trust, through a corporation, a for-profit corporation, to impact the choices and life decisions of 13,000 people. It's a truly unprecedented decision. If I could just quote for a moment what I suspect is familiar to you, the dissent of the Chief Judge in your circuit, Briscoe. She said this opinion was nothing short of a radical revision of First Amendment law, as well as the law of corporations, wholly unsupported by the language of the Free Exercise Clause or the Supreme Court's previous free exercise jurisprudence. She claimed, Judge Briscoe, that there was literally no support for the proposition that for-profit corporations enjoy free exercise rights in the Supreme Court's previous jurisprudence. And I'm struck by the extent to which the use of the term complicity and your description of a substantial burden on a sincerely held religious belief opens possibly floodgates for litigation on behalf of those who have sincerely held religious beliefs. As you mentioned, the issue here was access to family planning. There were more than 20 forms of contraception that could potentially be covered. There were only a handful, I think 4, that the Greens objected to.
Right.
How far does this new concept, this newly injected concept of complicity go?
Senator, it's not a new concept at all, with respect, because in enacting RFRA, Congress revived some older free exercise case law.
That's right.
Much of it written by Justice Brennan. Thomas would be a leading example, involving, I believe it was a Jehovah's Witness,
Yes.
okay, who was okay in producing certain goods that could be used as armaments, but not others.
Right.
Complicity in war making was
The
a
key
matter of
distinction-
faith to
The key
that.
distinction, if I could, Your Honor, between Thomas and this was that in that case, here's an individual whose deeply held religious belief made him say, I can't make turrets for tanks.
Right.
So the question is uniformly applicable law, unemployment insurance, can he benefit? Fine. But it doesn't in any way implicate others' liberty interests. The core concern with the choice to recognize a very large, multi-billion-dollar nationwide for-profit company and to privilege the religious interests of its owners through the legal fiction of a for-profit corporation is it impacts 13,000 individuals. That wasn't the case in Thomas.
Senator, respectfully, I think we're mixing apples and oranges, because the first consideration is whether we have a substantial burden on a sincerely held religious belief. The second is whether the government has a compelling interest narrowly tailored to override it. And I think we're mixing apples and oranges, because on the first one, complicity is very much in play, and it's the same in Thomas as it is with the Greens. How far does my religious faith, your religious faith, permit us to engage in things that our religion teaches are wrong, sinful? That's a matter of religious faith. And in fact, I don't recall anyone doubting or the government disputing that the Greens' religious faith was sincerely held on this score. So I think it's a given. So this complicity discussion, I think, frankly, Senator, is a red herring to mix my metaphors, because everyone accepted it.
We've got apples, oranges, and red herrings.
I know I'm
Gonna have a
mixing
full
my-
meal,
I
please.
know it's terrible. I wouldn't want to write it down in an opinion. It's terrible.
Well, let me take, if I could, let me take you to a number of things, because several other senators have referenced Hobby Lobby. One of the things that Judge Briscoe was saying was sort of category shattering or precedent setting was the extension to a for-profit corporation, the recognition of a for-profit corporation that sells crafts and hobby materials as being a religious corporation. Previously, only incorporated churches or synagogues or associations explicitly nonprofit religiously affiliated organizations have been recognized. In the interpretation of RFRA, you choose to define person to include for-profit corporations. Help me with why you made that move.
Be delighted to, Senator, and thank you for the opportunity. I think I'd point to a couple of things. First, RFRA is a statute, and it uses the term person, and it doesn't define the term person. And when Congress doesn't offer us a specific definition, we go to the Dictionary Act, which Congress has passed for just these circumstances. And there it says persons include corporations. That's the law, as Congress wrote it. And if Congress wishes to change the law and say only natural persons enjoy the rights of RFRA, I'm a judge. I follow the law. But the law, as drafted, doesn't distinguish between natural persons and corporations. It includes them both. And the government, Senator, if I might just finish, conceded, as I recall, and my recollection may or may not be great on this, but as I recall, conceded that nonprofit corporations can exercise religion.
That's right. And that's exactly why this was seen as such a departure. There was a long-settled expectation that religious free exercise rights adhered to individuals, living, breathing people, and to nonprofit corporations. It was a big leap for it to, for the first time, apply to for-profit corporations. And I appreciate that the opinion of the majority and your concurrence referenced the Dictionary Act. But the Dictionary Act actually says, on its own terms, that it applies unless the context indicates otherwise.
Right.
And the reality is, as I think one of the dissents points out, all Congress was intending to do, as expressed by a number of members of Congress, was to simply restore strict scrutiny, not to open up a whole new line of free exercise rights for-profit corporations. So I think the context clearly indicated otherwise. And to simply say, all I did was pull a dictionary off the shelf, look it up, person can include corporations, we're done with the analysis, is in some ways tendentious, because the idea that a for-profit corporation could have religious free exercise rights was nowhere in the earlier case law that Congress explicitly intended to be the narrow purpose of RFRA. So does Congress's intent when it passes a statute, its clearly stated intent, have any relevance to your interpretation, especially where something like the Dictionary Act actually urges you to look at the context?
Senator, I'll offer you two thoughts on that. First, as I recall, sitting here, and I have to go study my books, but the Supreme Court in an earlier First Amendment case did recognize a challenge by an Orthodox Jewish shopkeeper to Sunday closing laws.
That's right.
That was a corporation, for profit. So respectfully, I'm not sure it's accurate to say there's no precedent for it. Second, I would say to you, the position you're advocating is a fine position, respectable position. It's a good position. It was adopted by precisely 2 justices of the Supreme Court, and only 2.
So the question I want to ask you now is, at what point, given this newly adopted, fairly broad interpretive standard, when do we stop deferring to an employer's religious beliefs when they conflict with generally applicable laws of neutral meaning? When do we allow the right of one to implicate the others? I think it was Justice Holmes who was attributed to have said that your right to swing your arm stops at the end of my nose. And part of what I think made Hobby Lobby striking to so many was that the choices of 13,000 individuals about their method of family planning were overridden by the sincerely held religious beliefs of a very successful family. So I'm looking for how you find a limiting principle in this new field. What's the limiting principle now?
Senator, respectfully, I don't believe that's accurate either, because all the court held was that the government had to come up with another alternative to provide the contraceptive care it wished to provide. The court acknowledged, the Supreme Court acknowledged that there was a compelling interest in providing the contraceptive care, and simply said that an accommodation could be reached that didn't involve the Greens or require them to give up their sincerely held religious belief, much as had been done for churches
That's right.
and hospitals and lots of other entities. And the government couldn't explain why it couldn't accommodate other entities like Hobby Lobby as well, or Little Sisters of the Poor.
But if I might just briefly, Judge, strikingly to me, in the 10th Circuit opinion in which you participated, you didn't recognize as a compelling interest gender equity in providing health insurance to millions. The Supreme Court did. They balanced these equities differently. Why didn't you think that that was a compelling interest to provide access to health care for millions?
Senator, I think it was just a matter of what the record was in that particular case before us.
That's also a striking point for me. This was a preliminary injunction. It's a significant, groundbreaking opinion where one of your colleagues, one of the other 10th Circuit judges, said we really shouldn't be deciding something of this import on a PI. We ought to be remanding to develop the facts below. The facts weren't really well explored. And the larger point I'm trying to make is that I think this could lead to some very troubling applications. So let's just take a minute and look at a few of the contours of what this, I think, precedent-setting decision might mean. So let's imagine the Greens were from a different religious perspective. If they were Scientologists, for example, who reject the use of antidepressants, or Jehovah's Witnesses who reject the use of blood transfusions, or Christian Scientists who reject really modern medicine largely altogether, could their sincerely held religious beliefs as Scientologists or Jehovah's Witnesses or Christian Scientists lead to the conclusion that 13,000 employees could reasonably be denied access to antidepressants or to blood transfusions or to health care whatsoever?
No, Senator, not necessarily. It doesn't mean that at all. All it means is that the government, under the law as passed by this Congress, with overwhelming bipartisan support at the time,
Well, the ACA was not passed with overwhelming bipartisan support.
I'm sorry, I'm speaking of RFRA.
Right. The
religious.
accommodation is in the
Yeah.
ACA.
Oh, and the ACA, you can override RFRA anytime you want. Congress could say RFRA doesn't apply to the ACA. That's another alternative. You can abandon RFRA. You can say it doesn't apply to this particular statute. You can say it applies only to natural persons. You can say it doesn't apply to contraceptive care. Congress controls this decision, Senator.
That's right.
It's your decision. It's not mine, with all respect. We're just trying to implement what you've asked us to do.
So-
and Senator, on your hypotheticals.
Yes.
Okay. Justice Brennan wrote these First Amendment cases that you were seeking to revive. I'd remind you of that.
Yeah.
All right? Justice Brennan. All right? And the fact of the matter is, sometimes the government can prove a compelling interest and that it's got the most narrowly tailored way to get there. And sometimes it can't. And each case has to be taken on its facts in the particular context in which it arises.
Well, then help me walk through, if you would, given we already know how you draw the compelling interest line in this particular instance of access to family planning or contraception. How else might you weigh these equities or draw these lines? If the Greens, for example, in Hobby Lobby, knew that several of their employees would spend their paychecks on other things they might say were immoral, like gambling or prostitution, could they refuse to endorse their paychecks?
Senator, it would go back to, we do the analysis,
Right.
the same analysis. Do they have a sincerely held religious belief? Sometimes people don't. I've had claims, for example, of individuals.
But in this instance, wouldn't you agree that their sense of the complicity that you referenced in your opinion would likely apply?
It depends.
Even though it's very attenuated.
Oh, no,
The choice of their employee to spend their money in a way they disapprove, isn't that different from the choice of the employee to choose among 24 forms of contraception, one of which they strongly disapprove?
Senator, I think it depends on the facts of the case. So, for example, I've had a case where a number of people came before us and said, we have a sincerely held religious belief that marijuana is God. Okay? It turned out it was a drug distribution ring,
Right.
all right? And what they really worshiped was the
I'll
almighty
remind you,
dollar.
many of us have teenagers at home watching.
Right, well, and they were really just trying to make a buck, okay? And the district court found that that wasn't a sincerely held religious belief. So that you can get off the train there. That's one place where you may get off the train in your hypothetical. You got another place you can get off the train. Is it a substantial burden?
Right.
Another place is compelling interest by the government. Another place is narrowly tailoring. So there are 4 steps in the process, and you have to go through all 4 of them as a good judge with the facts of each case as it comes. And Senator, again, it's all statutory. You could abolish it tomorrow.
Well, let's take an example that I think was central to a lot of this analysis, United States versus Lee. It's an older case, 1982. It was a unanimous case. It's one where an Amish businessman declines to pay for Social Security taxes, not just for himself, but for a few of his employees. And the court rejected his claim because the restriction on religious freedom, in their view, unanimously, was essential to accomplish an overriding governmental interest. Is Lee still good law?
I think Lee would be the sort of law you look at when you're applying RFRA, absolutely.
Because RFRA simply restored the strict scrutiny standard that Lee was decided under.
The Religious Freedom Restoration Act, exactly. So that's a very good example, Senator, of where the government was able to prove compelling interest in narrow tailoring. Yes.
Because the ability to have a Social Security scheme nationally that is sustainable is a compelling interest,
Yes.
but a nationwide plan to provide access to health care isn't.
No, Senator. Again, I think we're mixing our apples and our oranges because the government in the ACA was spotted the compelling interest. The problem was the narrow tailoring. You could get there without forcing the Greens to do something their religion prohibited. So it wasn't like the system of Social Security, which depends upon everyone's participation. That was a distinction the Supreme Court drew.
Let me just quote, if I could, Justice Scalia, who addressed this same issue in Employment Division v. Smith, and who said, "It's precisely because we're a cosmopolitan nation made up of people of every conceivable religious preference, and precisely because we value religious divergence, that we cannot afford the luxury of deeming presumptively invalid, as applied to the religious objector, every regulation of conduct that doesn't protect an interest of the highest order. Now, obviously, the law's changed in terms of the review standard, but do we, because of Hobby Lobby, now have to deem every law to be presumptively invalid if it offends any conceivable religious preference?
Under the Religious Freedom Restoration Act, it's a four-part test, effectively.
Right?
All right? And for every challenge, you ask those questions. Is there a sincerely held religious belief? Is there a substantial burden on it? If check, check, then you go to the government side of the ledger. Do they have a compelling interest? And is it narrowly tailored? And that's the law you've set forth, Senator, because this body didn't like, frankly, Justice Scalia's decision in Smith. And if this court, if this, the old trial lawyer in me, sorry, getting tired. If this Congress wishes to say Justice Scalia was right in Smith and we've changed our minds, that's entirely up to this Congress.
Well, I'm going to move on to another line of questioning, but I just want to say that one of the challenges I face in a couple of different gates through the analysis as laid out was how you decided to interpret the underlying RFRA statute, how it was extended to for-profit corporations, how the balance was struck between what I think are the mediating decisions of thousands of individuals versus the free exercise of the Greens. You've talked about being a Westerner. You've, I think, entertained us with mutton busting, something I haven't seen yet, and clearly I should. And I'm interested.
I recommend it.
I'm interested in your view of privacy and the autonomy of adults to make their decisions. It was, in fact, I think, Justice Scalia who said there isn't a genuine Westerner on the court and that California doesn't count. As I shared with you, some of my extended family was from the West, and I think of Westerners as steadfastly independent folks. Justice Douglas, a famously Western justice, once said, "The right to be let alone is the beginning of all freedom." So in 2006, you authored a book, The Future of Assisted Suicide and Euthanasia, a topic of intense personal interest to many. And when reviewing your book, I was expecting you to conclude that people have the right to be let alone, because I think of that as an inherently Western trait, to make important and difficult personal decisions without the interference of government, but you didn't. Instead, you expressed a belief in the inviolability of human life. What did you mean by that?
Senator, respectfully, I'm not sure I'd agree with your characterization.
Of the book or of being a Westerner?
Of the book. I agree with your characterization of being a Westerner. The book does conclude that Cruzan is absolutely correct, that there is a right to be left alone at the end of life. These are hard decisions. I don't pretend to have any perfect answers here. I was writing this book, it was my dissertation, trying to contribute to what I thought was a very hard question. I still think a very hard question, one we all have had personal struggles with, Senator, as I know you have and I have. And this is a human problem. We're mortal. Cruzan held that people have a right to be left alone, presumptively, under the common law, presumptively constitutionally, to stop care, go home, die in your own bed, as a lot of my family members have done. The question is whether you should also have an additional right to have someone kill you, involve doctors in killing. And there are good arguments on both sides of that ledger, as I explore in the book.
Well, if I can, Judge, I'd like to help walk through that exploration of what you looked at in the book. And I think the Cruzan decision is a very important one. Because essentially the tension here is between whether there's a right for a conscious terminally ill adult to end their own life by refusing life-saving hydration and nutrition, as the Supreme Court assumed in Cruzan, or with the help of a doctor. And a lot of this rests in whether there is a right to privacy. Do you believe the Constitution contains a right to privacy?
Yes, Senator, I do. Privacy is in a variety of places in the Constitution. The first and most obvious place, back to the Bill of Rights, is the Fourth Amendment, right? The right to be free from unreasonable searches and seizures in your homes, papers, and effects. That's privacy, right? The Third Amendment, which I alluded to but didn't want to reveal,
Quartering of troops in home.
no quartering of troops. Stay out of my house with your troops. Now, happily, we don't litigate that much. Right? The First Amendment, right? The right to free expression, which we've been talking about, and the freedom of religious belief, expression, that requires a place, privacy. And the 14th Amendment, Senator, over now about 80 or 90 years, the Supreme Court of the United States has held that the liberty prong of the Due Process Clause protects privacy in a variety of ways, having to do with child rearing and family decisions, going back to Myers, which involved parents who wished to have the freedom to teach their children German at a time it was unpopular in this country, and Pierce, the right of parents to send their children to a parochial school if they wish. So, Senator, yes, the Constitution definitely contains privacy rights.
One of the things that you say in your book, unequivocally, is that, and I think I quote, all human beings are intrinsically valuable, and the intentional taking of human life by private persons is always wrong. And I think that's a dividing line you draw between the facts in Cruzan and what has been proposed or adopted in states like Oregon. Can you point to any principle of constitutional law that says that, or has that principle, as you enunciated it, ever been offered by the Supreme Court or recognized by the Supreme Court?
Senator, I was speaking as a commentator before I became a judge, not expressing views as a judge, all right? My views as a commentator I'm happy to talk about, though. I found this a very difficult question. The Supreme Court has held that this is an issue for the states to decide under Glucksberg and Quill, for the people to decide on the state level. I agree with those decisions. I say so in the book. My concern about legalization that I express in the book as a commentator has to do with the equal protection principles we've been talking about today, the equal justice under law principles. And I am concerned, in the book, I express concerns as a commentator about what legalization might mean for the least amongst us, the most vulnerable, the disabled, the elderly, who might be pressured into accepting an early death because it's a cheaper option than more expensive hospice care, things like that that might cost more. And so that was a concern I expressed. Senator, I don't pretend, though, to have the last word on that or to know the right answer. I was contributing as a commentator to what I thought was a very hard discussion.
It is a very, very hard discussion, as you said, something that has an enormous impact on the terminally ill and their families.
Yes.
There was a case that I think was active at the time you were at the Department of Justice, where the U.S. Attorney General was suing Oregon to block their death with dignity law that permits, in that state, physician-assisted suicide. And in the documents you produced to this committee, you sent a message expressing hope that the federal government would win that particular case. Why did you want the federal government to win that case?
Well, I was an advocate for the government at the time, Senator. That's my job, all right? When you represent the government, you want the government to win. When you represent somebody against the government, you want the government to lose. And as a judge, Senator, it's a very different mindset.
And when you're up for consideration for the Supreme Court, it's important to know what you view as settled precedent. So let me, in my last 2 minutes, ask a question or two about that. In the Glucksberg case, which is about physician-assisted suicide, Justice Stevens said in his concurrence that avoiding intolerable pain and indignity of living one's final days incapacitated and in agony is certainly at the heart of the liberty to find one's own concept of existence, citing the Casey decision. What's your view of the application of Casey's mystery of human life language here?
Senator, the Supreme Court in Glucksberg, the majority held that this issue is for the states to decide and the people to decide. People of Oregon have made their decision to legalize it, for example. It was just legalized in November in my home state of Colorado. That's their right.
And how did you feel about that?
Senator, my personal views have nothing to do with my job as a judge.
Let me ask one last question, if I might. There was a line in your book that reminded me a great deal of Justice Scalia. You said that a libertarian principle legalizing physician-assisted suicide would require the government, inevitably, to allow sadomasochist killings, mass suicide pacts, duels, the sale of one's own life, not to mention illicit drugs, prostitution, the sale of one's organs. Help me understand, in closing, why finding a constitutional right to physician-assisted suicide would directly yield to this long list of other, perhaps more shocking constitutional rights to prostitution or drug use or the sale of organs. Help me understand that leap.
Senator, in each chapter, I analyzed different potential arguments, one of which was this libertarian argument, and applied faithfully to its end, it leads to where it leads, as some of the authors of the argument acknowledge. I'm not making it up. There are other arguments, though, that one might deploy that I analyze as well. That's not the only available argument for legalization by any means.
Thank you, Judge. Thank you, Mr. Chairman.
We